Hello, my name is Lloyd Chapman, and I'm the president and founder of the American Small Business League. And we had a case in federal court in San Francisco, an injunction to stop the SBA from giving federal small business contracts to Fortune 500 firms, and to stop the SBA from fabricating the government's compliance with the 23% small business contracting goal by excluding 2/3 of the federal acquisition budget. And unfortunately, the judge dismissed our case, and he canceled the hearing so we couldn't have oral argument, and then dismissed the case. And this is the judge's declaration of why he dismissed it. He said the upshot is that Congress enacted a statute requiring the Small Business Administration to provide information about the participation of small business in federal contracting. If the Small Business Administration is giving Congress bad information, then Congress should do something about it, either in an oversight or legislative capacity. Having requested the report, Congress, not the judiciary, is in the best position to decide whether it's gotten what it wants. I disagree with that. I don't think that Congress passed a Small Business Act to make sure that the SBA reports to Congress. I think that Congress passed a Small Business Act to ensure that a minimum of 23% of all contracts go to small businesses. So this is just a judge opinion about this. Let me just read directly from the Small Business Act. The government-wide goal for participation by small business concerns shall be established at not less than 23% of the total value of all prime contract awards of each fiscal year. Each agency shall have an annual goal that presents for that agency the maximum practical opportunity for small business concerns. And then when the Small Business Act defines a small business, it says the definition of a small business is an independently owned and operated company that is limited in size and revenue depending on the industry. The largest size standard for any small business is, I believe, 1,500, and probably 90% of the small business categories is 500 or less. So I believe it's very reasonable that our lawsuit should have been allowed to proceed. Here's what I think the judge should have said. Here's what his ruling should have said. The SBA's policy of diverting federal small business contracts to Fortune 500 firms is inconsistent with both the letter of the law and the congressional intent of passing the Small Business Act. The SBA's exclusionary rule, whereby they exclude up to 2/3 of the federal acquisition budget in calculating the percentage of awards to small business, is also inconsistent with the letter of the law that requires a minimum of 23% of all contracts to be awarded to small businesses. And for that reason, the SBA's motion to have the case dismissed is denied. That's what it should have said. So we'll be appealing that case to the Ninth Circuit Court of Appeals before the end of October. And I think we're going to win that case. I've won about 98% of the federal cases that I've filed against the government that have gone to court. And I think we're going to win this one. And we do. When we do, it's going to redirect over $250 billion a year in existing federal infrastructure spending back to middle-class small businesses and create about 2 million jobs a year. I'm Lloyd Chapman, the American Small Business League. Thank you.